Is this what you picture when you hear misappropriation? Most trade secret misappropriation claims are much less fanciful and come up when an employee begins working for a new employer or a potential business deal doesn't work out. Today we're going to focus on what constitutes misappropriation of trade secrets, both when there's a breach of a confidential relationship, as well as when the appropriator has used improper means. And we'll also talk about what misappropriation doesn't include. Hey Bill, you get that card catalog up and working?
Hi Sid, how you doing today?
Good afternoon, Mr. Rantanen. I'm doing fine, I suppose, but I'm really anxious about a legal issue that could potentially become a problem for me.
Yeah, I see from your consultation form that you're concerned about some accusations that a previous employer is making about you. Can you tell me a little bit more about your situation?
I used to be the general manager at the Cherry Blossom, that high-end restaurant in Midtown, you know? And the clientele there, well, they loved me. They always wanted to make sure I was working if they were coming in. A lot of them even texted me on my personal phone to make reservations, and I loved working there until the Cherry Blossom changed ownership.
I see. Go on.
The new owners and I just never saw eye to eye. Eventually, they fired me over some botched table linen order that I had nothing to do with, but whatever, it was all for the best. If they hadn't fired me, I wouldn't have had the kick I needed to open La Fleur Pommier.
Okay, so you left the Cherry Blossom and opened your own restaurant, La Fleur Pommier.
Yep, and as soon as my grand opening is over, I start hearing things through the grapevine that the owners of the Cherry Blossom are talking about me and La Fleur Pommier. They're accusing me of stealing some recipe for one of their desserts, taking customer data with me, and copying their service manual. I don't know how much weight is behind their accusations, but now that I have my own business, there's a lot on the line.
Certainly. From what you told me, Sid, it sounds like the owners of the Cherry Blossom could be building a case against you for trade secret misappropriation.
Misappropriation, huh?
Misappropriation of trade secrets. Here, let me break it down for you and stop me if you've got any questions along the way. A trade secret is any information that has economic value from being a secret and that the owner takes reasonable measures to keep a secret.
I'm not quite sure I'm following.
It can be a bit confusing, I agree. And let me try explaining it with a visual aid. As the yellow circle shows, there's information that is secret, say, like what you had for breakfast. But is that information valuable to a business?
Not really.
Right. Then as the blue circle shows, there's other kinds of information that's valuable. Say the idea of using cream of tartar when you're whisking egg whites. But is that information secret?
Nah, a lot of cooks know about that trick.
Exactly. Plenty of people know useful cooking tips. But where these two circles overlap, say in this green segment right here, we have information that's valuable because it's a secret.
Okay, now I think I understand. So that green part, those are trade secrets?
Right. So it sounds like your previous employers are going to assert that the recipes, the customer data, and the service manual are all trade secrets that you took when you left and opened your own restaurant.
I've heard the word misappropriation, but I'm not quite sure what it means here.
Sure, let me try to clear that up. So misappropriation can mean a couple of different things. In some cases, it can mean that the trade secret was taken through improper means.
What exactly constitutes improper means?
Improper means include stuff like theft, espionage, inducing employees to reveal information that their employers want to keep confidential, stuff like that.
I think I get it. But what about a situation where someone is skilled in a certain field, like, say, a chef, and they just figure out a secret, like a recipe, by tasting it and applying their knowledge to recreate it?
What you've just described sounds like reverse engineering, which is actually a proper way to discover a trade secret. But it also points to the fact that a lot of times these trade secret misappropriation questions can enter an unsettling gray area.
I'll say.
Misappropriation can also mean the use or disclosure of confidential information without the owner's consent. This is called breach of confidentiality, and I suspect it's the way that the Cherry Blossom owners see the situation.
Can you say a little more about that? I don't think I understand.
Sure. A breach of confidentiality arises when someone owes a duty to someone else to keep the information confidential. I'll give you an example. Let's say we've got an employee that's working for an employer, and the employee has access to the employer's trade secret. But at the same time, the employer has made it clear that the employee is supposed to keep that information confidential. If the employee uses that trade secret without the employer's permission, that could be an instance of breach of the duty of confidentiality. But there's an added layer to this. There must be some kind of prior agreement between the employer and the employee that the information is going to be kept confidential.
Well, I never signed anything when I worked for the Cherry Blossom. I mean, what you're talking about sounds like a contract.
Well, the agreement could be in writing, like a written contract or non-disclosure agreement, but it doesn't have to be in writing. It can also be inferred based on a common understanding. Say everybody in the company knows that you have to keep this information confidential, but that's harder to prove than when there's a written agreement.
Okay.
I know this might seem overwhelming, especially since La Fleur Pommier is your first independent venture. But you're doing the right thing by talking to a professional who can help you navigate these accusations. Let's walk through the circumstances of your employment and of the information that the owners of the Cherry Blossom are accusing you of taking, so we can talk about it in a little more depth.
The basic concept of misappropriation in trade secret law is pretty straightforward. Often the challenge lies in drawing lines in complicated or gray situations. We'll start with the statutory law. The Federal Defend Trade Secrets Act, codified beginning at 18 U.S.C. Section 1836, defines misappropriation in Section 1839 in a pretty typical way. Although when we look at the definition in its entirety, with all of these subparts and different elements, it can appear pretty intimidating. So I'm going to walk you through the definition of misappropriation. And along the way, I'll highlight a couple of things so that it all makes sense. As you'll see, there are basically two forms that misappropriation can take: using improper means to acquire someone else's trade secret and breaching a duty of confidentiality. To start, let's look at this first part. Under subsection 5b Romanet 1, misappropriation means the disclosure or use of a trade secret of another by a person who used improper means to acquire the trade secret. For example, if one of Sid's employees stole a recipe book from Cherry Blossom, then that employee would be a misappropriator if he uses or discloses that secret. This type of misappropriation focuses on whether the trade secret was acquired by improper means. If it was, then the acquirer is a misappropriator if they then use or disclose that secret. So what exactly are improper means? Section 1839 tells us. It states that the term improper means includes theft, bribery, misrepresentation, breach or inducement of a breach of a duty to maintain secrecy, or espionage through electronic or other means. Those do sound pretty improper, don't they? But to be extra clear, Section 1839 also explicitly identifies some things that do not constitute improper means. One of those is independent derivation of the trade secret. For example, if two companies each independently developed the same process for making ethanol, and both kept it a secret, each company couldn't claim that the other company misappropriated its trade secret just because the other company had also developed the same process. This portion of Section 1839 also makes it clear that reverse engineering is not an improper means of acquiring someone else's trade secret. In other words, taking apart a competitor's product to see how it works, or starting with a product and working backwards to figure out the method by which it was developed, is permitted under the statute, provided, of course, that the product that's being examined was acquired lawfully. Of course, just because it's okay to independently develop something that's the trade secret of another, or to figure out the trade secret through reverse engineering, doesn't prevent there from being another basis for a claim of misappropriation. So it's important to examine all angles of a situation before jumping to conclusions, and to clearly lay out your analysis. The second type of misappropriation involves the breach of a duty of confidentiality. When we look at section 5b Romanet 2 Roman numeral 2, you can see that misappropriation means the disclosure or use of a trade secret of another without express or complied consent by a person who at the time of disclosure or use knew or had reason to know that the knowledge of the trade secret was acquired under circumstances giving rise to a duty to maintain the secrecy of the trade secret or limit the use of the trade secret. This type of misappropriation focuses on the idea that someone who's given a trade secret may be under an obligation of confidentiality. As a result, the recipient of the trade secret must maintain the trade secret in confidence. In addition, the circumstances in which the recipient can use the trade secret may be limited. The underlying idea here is that there's some sort of agreement or legal duty regarding the disclosure or use of the information. Perhaps that duty is just generally understood based on the circumstances, or perhaps there's a formal contractual limitation on the use of the trade secret. For example, if Sid obtained Cherry Blossom's trade secrets while under a duty to maintain the secrecy of those secrets, he could be a misappropriator if he disclosed or used the trade secret. Even if Sid didn't sign a non-disclosure agreement, courts may conclude that a duty of confidentiality arises from the employment relationship itself. You'll also note that the Defend Trade Secrets Act can impose liability on a third party who's aware that the trade secrets were acquired under a duty of confidentiality or through improper means. For example, under 5A, misappropriation means the acquisition of a trade secret of another by a person who knows or has reason to know that the trade secret was acquired by improper means. So if one of Sid's employees used improper means to acquire the secret of a competitor and then passed it on to Sid, Sid could be a misappropriator if he knew that the competitor's secret was acquired through improper means. Or if Sid shared Cherry Blossom's trade secrets with one of his own employees, and that employee left to start their own restaurant, that employee could be liable to Cherry Blossom if the employee knew or had reason to know that Sid acquired the trade secret while under a duty of confidentiality to Cherry Blossom. Finally, you'll also note that there's a category of misappropriation at the end that addresses someone who accidentally acquires knowledge of a trade secret and then learns that it was a trade secret before they do something with the trade secret. In addition to allowing individuals to bring legal claims for trade secret misappropriation, governments may also prosecute trade secret misappropriation under criminal statutes. In a criminal misappropriation case, the legal claim is brought by a government prosecutor. Sentences can include both imprisonment and large fines. While criminal prosecutions for trade secret misappropriation are much less common than civil actions, they do happen. There are both state and federal criminal trade secret misappropriation statutes. The federal statute contains two main components. Title 18, Section 1831 provides criminal sanctions for theft of trade secret to benefit a foreign government. This is typically referred to as economic espionage. Section 1832 provides criminal sanctions for the theft of trade secrets used in connection with interstate commerce. This is commonly referred to as theft of trade secrets. Together, Sections 1831 and 1832 allow the government to prosecute foreign and domestic theft of commercial trade secret information. Most elements of criminal trade secret misappropriation are the same as civil misappropriation. For example, the definition of trade secret in the federal criminal statute is the same definition as the federal civil trade secret misappropriation statute. However, establishing criminal trade secret misappropriation generally requires showing that the defendant had actual knowledge that the information was a trade secret, rather than the knew or should have known standard for civil misappropriation. In addition, criminal prosecutions often involve a higher evidentiary standard, that is, beyond a reasonable doubt, as compared with civil actions which require that the elements be proven by the preponderance of the evidence. However, criminal trade secret laws may encompass conduct that civil actions do not, such as attempted trade secret misappropriation. Trade secret misappropriation may also implicate other crimes, such as violations of the Computer Fraud and Abuse Act. So remember, while prosecutions under criminal trade secret laws are uncommon, they do happen. The more you know, the better you're prepared. To make sure that you're comfortable with the concept of trade secret misappropriation, we're going to read and discuss two court opinions involving claims of misappropriation: DuPont versus Christopher and Uncle B's Bakery versus O'Rourke. Both of these cases were litigated in federal court. However, as I talked about in the last episode, up until recently, there were no federal civil actions for trade secret misappropriation. Instead, both cases involved the application of state law. For example, the law at issue in DuPont versus Christopher is Texas state law. Don't be surprised by this. Federal courts can hear claims involving state law under some circumstances. But do be aware that in both cases, it's state law, not federal law, that's at issue. At the same time, remember that the fundamentals of trade secret misappropriation in the United States are basically the same, regardless of the specific jurisdiction. The first opinion, DuPont versus Christopher, provides an example of the kinds of activities that can constitute improper means. It also illustrates how technological change can intersect with existing law. I won't spoil the story for you, but as you read it, keep in mind that the activities discussed in this case took place in the 1960s, an era with many differences from today. There was no public internet in the 1960s, no smartphones, and certainly nothing like Google Maps. As you read it, though, imagine how it might play out in the world today. Do you think the court would reach the same conclusion? The second opinion, Uncle B's Bakery versus O'Rourke, is also in federal court, but this time the court is applying Iowa state law. Here, Uncle B's Bakery is requesting a preliminary injunction against O'Rourke, a former employee. Now, a preliminary injunction is a type of relief that a court can enter before a trial is held. Preliminary injunctions are typically used to address harms that delay would make significantly worse. Deciding whether to grant a preliminary injunction requires that the court determine what the likely outcome of the case will be. It also requires showing that the party seeking the preliminary injunction, in this case Uncle B's Bakery, would suffer irreparable harm in the absence of the injunction. A major benefit of a preliminary injunction is that it can help maintain the status of the secret while the misappropriation case is pending. However, because it's entered before a full determination on the merits, the moving party has a hurdle to overcome to demonstrate that the preliminary injunction should be entered. That's about all you need to know for now. So with that, I'm going to sign off and let you dig in. Hey guys, I'm really hungry. Let's go do a bagel run. I hear there's a great new place that opened up down the street.